Welcome on this course on the protection of personal data in a business context. In this course, we'll focus on the protection of personal data in particular, and there is a distinction here to be made between different kinds of data. So when you talk about the protection of data, the debate or the questions can be quite difficult to understand because you have different ways to discuss this data to be protected. So on this slide, I want to explain the focus of personal data protection. As you see, personal data is not, we will not consider the kinds of data sets which are recognized as a creation of the mind. Indeed, anything that is recognized as basically an act of creation by somebody falls in the category of intellectual property. And in this case, all the questions related to how this data should be shared, who owns this data, is regulated by intellectual property rights. Here we will not focus on that. We will not focus also on the issues surrounding cyber security. Indeed, the protection of data is very much the topic of all all the tools, all the procedures that you can use to protect your data from hackers or from the surveillance of the state or from economic intelligence spying. This is very interesting and very important, but that's not the topic for today. Today we are going to discuss how personal data, that is the data that relates to individuals, needs a management for itself. So now we will clarify a bit what we mean by data. We mean by that any information that can be processed automatically, presumably on computers. So it's the protection of data does not concern, let's say, the written notes that somebody would have kept in a company, or anything which is basically not structured. It doesn't mean that just data on computers is considered. If you have paper records, files on paper that you need to keep in order to transfer them to computers later, this is considered as data. And finally, a strong hint at what constitutes data is the fact that you would have a filing system. If you have sheets of paper where you keep records of anything, and these sheets of paper are organized in a systematic manner in order to make it easier to retrieve specific information about specific individuals or things, then it is considered as data. So the main takeaway here is that data is, of course, very often something that you will find on computers or servers, but not only. So why should personal data be a topic in itself? Very simply because individuals have the right to their privacy and their rights to, the basic rights as individuals are very much contained in this data. So if you would not have anything to protect personal data, the users would basically see their privacy being violated. On the company's side, the failure to protect personal data, which they have, can lead to their prosecution. So, for example, in 2014, Google was condemned by the French authority to a fine because they failed to update their privacy policy. So they were fined for this relatively small amount, but maybe more importantly, they were also fined to and obligated to put a notice on their homepage. So Google, when you had to make a search on Google, you had in February 2014, you would see a notice on the Google search engine that Google had been condemned for the failure to comply with privacy rules. So this is one of these big companies, but every state in Europe has regulations that regularly make sure that businesses, small and large, comply with privacy rules. Okay, so what are the legal frameworks in place to protect personal data in businesses? In the European Union has probably the most restrictive legal framework in place to regulate personal data. The goal of this framework is to make sure that within the European Union there is an homogeneous legal framework between countries, so that if a user subscribes to, let's say, a service in Spain or buys a product in Spain, to make sure that the data owned by a Spanish business, if this data would be transferred to another state in the European Union, to make sure that this data would be protected at the same level. In order to do that, you need a European legal framework. That's what it does. Very importantly, that puts the boundaries to data transfer by businesses, the boundaries to the European Union. If you would, as a business, export the data of the users from your company, of the customers, to a state outside of the European Union, you would have to show that the state where you transfer the data has at least the same level of data protection, personal data protection, as in the EU. So, an important distinction that this legal framework does is a distinction between what is a data controller and a data processor. In order to know who is in charge of the protection of personal data in a business, the data controller is the one that manages and establishes the rules for data management. This is the one that will be ultimately legally responsible for any data breach or just a violation of data privacy in a company, because the data controller is the one that specifies how the data will be handled. The data processor is the one that will actually put or implement this policy defined by the data controller in practice. So the data controller is basically the manager, and the data processor is the tool or the solution which is being used to enforce the policy of personal data protection defined by the data controller. So you have this EU framework, but beyond that you have subtle distinctions in each country. So I just give you an example of how personal data is defined in slightly different ways in the UK and in France. So in the UK, the definition of personal data is provided by the Information Commissioner's Office, ICO, and they define personal data as any data that relates to a living individual who can be identified from the data itself, of course, or from a mix of this data and other data sources. So that's interesting. The data the personal data that a business should protect is identified as such, also in combination with other information which could be mixed with this data. Note also the reference to any expression of opinion about the individual. That means that if you store, let's say, a list of employees in your data set, this is personal information. But what is also personal information is what you as a business add to this data set. So if you add ratings or commentaries on each of these employees, this is personal data. This is considered personal data relating to this employee. You see that it's a very, very important broad conception of personal data. In France, the definition of what is considered as personal data is provided by the CNIL, the National Commission on Informatics and Liberties. They do not refer to a living individual, but what they add, for example, is how a person can be related to the data set. One should consider all means available to the agents holding the data or to anyone else. So here we have a reference not only to how the data in itself can be mixed with other data sources to identify somebody, but it also refers to the tools. So think of algorithms, for example. It refers to the tools that would make this data relate to an individual. So let's say if you have just, as a business, you have in a data set a list of locations where your customers, that your customers visited, a list of shops, let's say. You have no personal information here, just a list of places that some customer visited. But if you have an algorithm that allows you to reconstruct from this type of information, if you can reconstruct who is actually visiting all these places just by inferences, for example, then it qualifies as a personal data set, and it should be protected and declared as such. So note the insistence on the tools that participate to the definition of what is a personal data set. Now we'll just do a brief tour of different countries and what is their particular take on the protection of personal data. Let's start with the US, where the situation is quite simple. You have first a very strict regulation framework that applies to personal data which is held by the federal government. Here you have this framework defines how citizens can access that data, how they can ask to be this data to be modified or deleted. So you have for the federal government a pretty extensive framework for the protection of personal data. But outside of it, for any data which is personal data which is held by businesses or NGOs or whatnot, you have no unified legal framework that defines how this personal data should be protected. It is basically quite a free a free state. The problem with that is that if you are an American business and you want to if you want to open a branch or develop operations in the EU, as I explained before, the EU has a very strict legal framework for the protection of personal data, so you will not be able as an American business to transfer data from your European servers to your American servers. The reason is that on American servers, well, you can do whatever you want. There is no regulation on personal data. So it's basically forbidden to do that, except if the company, your American company, subscribes or participates in the Safe Harbor Act. The Safe Harbor Act is a legal framework put in place for American companies that want to basically do business with Europe. In this case, companies that voluntarily participate in the Safe Harbor Act must comply to the EU regulation on the protection of personal data. In this case only, they have the right to basically export personal data from the EU to their servers in the US, where this personal data will have to be protected according to the principles that are the same as in the EU. Now, India. In India, you have two acts that define how personal data is protected. You have the IT Act of 2000 and the IT Rules of 2011, and these rules put a special focus on sensitive personal information, such as passwords or financial information or sexual orientation. A difference with the EU is that there is no need or no obligation to declare data processing activities to an authority. In China, there is no overall legal framework for the protection of personal data. What you have at the national level is two general laws on network information protection, and then you have sector-based pieces of legislation, for example, the one on the protection of telecom and internet users. But these things do not cover other areas of business. So the situation in China is much more, a bit like in the US actually, is harder to clarify. In Brazil, they have this interesting notion of habeas data, which is a reference to the habeas corpus, a basic right in the Anglo-Saxon legal world, and the habeas data is a principle that defines a right for an individual to access and edit their personal information in public and consumer databases, even after their consent has been granted. Brazil has no privacy regulation authority, which is also a difference with EU states. In Russia, sensitive data, so data relating to race or politics, requires consent in written form before processing. And there is a supervision authority which is basically in charge of registering all the activities that process data. Interesting to note, Russia has no specific regulations on cookies. Okay, so what are the common points that you will find in all these different legal frameworks? Again, with national specificities. First, before processing personal data, consent must be obtained. Second, adequacy should govern the rule of collection and processing of data. Then transparency, the user should be able to have a view on which personal data businesses have on them. And finally, safety. Reasonable procedures should be taken to protect personal data. So we'll now see each of these principles in turn. So the consent in the digital world is very much discussed in the context of cookies. Cookies are these little pieces of code that a website can write on your computer in order to identify your computer, so that when you visit new web pages or web pages essentially, this information can be sent to the business. The EU has enforced a policy where the cookies that a website writes on your computer, these cookies should be agreed by the user, and the role of these cookies should be explained to the user before the user agrees. I'd like to insist here on the fact that cookies are just the tip of the iceberg. Actually, if a company wants to track you, your behavior online, of course they can use cookies, but that's a bit old-fashioned. There are many other ways to know who's visiting a web page without having a cookie stored on their computer. So regulating cookies is good, but it doesn't mean that users are not being tracked by other ways. Adequacy, that basically relates to the fact that the data collected about users should be useful for the specific business purpose that is being given to the being served to the user. So that's what you see when you install apps on a mobile phone. These apps ask you for a series of authorizations, and these authorizations should relate to the service. Same when you have a social media login. Transparency. Transparency means that users today should have a right to access, edit, and delete their information that you collect on them. The latest development on that is the right to be forgotten, which is the result of a ruling by the EU, where users should be able to ask search engines to delete past information on them, which could be detrimental to them. And finally, safety. Of course, businesses should take care of make sure that the personal data that they have is protected. But that means that the level of protection should be adequate to the level of damage that a data breach would cause. And one of the basic things that a security policy should do is define roles of access. So not anybody in a business should be able to open any file. The rights of who can do what should be precisely defined. And if not, well, the local authorities could actually give a fine to the business. So that's the basic view on personal data protection. Now I'd like to develop on how is big data changing the deal. Because until now we have discussed how data sets should be protected in order to not reveal personal information. However, it might be the case that with data mining techniques, with basically a knowledge of how data can be processed, a data set which in itself holds no personal information can be data mined and reveal a lot of personal information. So it's not because you protect one data set that personal information is safe. An algorithm or a tool applied to this data set is the place where personal data can actually be created and reconstructed. So I'm going to give you a couple of examples. For example, a team of Harvard researchers had worked on a Facebook network of students from 4 anonymous American universities. So they had 1.2 million Facebook users from these universities, and they were anonymized. So we didn't have their names, and we just had a couple of demographics on them, such as gender, age, place of birth. So the data set in itself is completely anonymized. But because we had network information on these individuals, who befriends whom, it could be actually possible to reconstruct social networks, and at the end pinpoint who is whom in the social network. So this team was actually accused by a fellow researcher of revealing personal information in this data set. A second example is the London Bike Share program, which open source that gave as an open data set the list of users identified just by the ID, anonymous ID, and where they were traveling. And an investigator revealed that even if you don't know who is traveling, just looking at the place where they travel would actually reveal a lot on who they are, and private information on their habits. On this slide, you would see that this person has their home in one particular place, but a couple of days per week or per month they are sleeping over in another place. That's quite private information revealed for anybody to see. And another example is the cab dataset, the New York City taxi cab dataset, again, which revealed just anonymous passenger taxi ride information. But this investigator could reconstruct the fact that Bradley Cooper was the one who took this particular taxi ride, and that he actually did not pay a tip on the ride. Just because when you put different data sets together, looking up on sources of information, you can end up recognizing who is relating to this data. And the same with Jessica Alba. So, given that the data set in itself does not reveal personal information, but with the tools from big data or data science, you can find who these persons are and what information relates to them. What should you do to actually protect these things? The first thing is that you should be aware of that. You should not take a data set just for itself. You should think ahead and try to imagine how this data set, when put in the context of other data sets and in the context of data mining tools, how this data set could become harmful. The second thing that you should be particularly aware of are these data sets that contain geolocalized or network or time-stamped or textual data. These types of data, even if they are anonymous, can easily lend themselves to reconstruction of personal identifiable data. And finally, beware the long tail. Even if most of the anonymous profiles that you have on your data are all looking like the same and very hard to disentangle, you will find a couple of profiles that are so unique that it's then very much possible to guess how are these unique profiles relating to a person that you can identify. And finally, a last note on how is personal data information, the protection of this data, different given what we know after Edward Snowden's revelations. Well, you should make as a business the assumption that your national state and maybe other national states have access to your servers. if you just use the cloud solutions, the basic assumption that you should make is that the users or the personal data that you store on these servers will be accessed or can be accessed by national authorities. So it's both a reality, a likely reality, and it's also maybe something for a business opportunity. Given the revelation on the NSA, in France, for example, a couple of cloud solutions advertised the fact that their servers stayed in France and that they were encrypted. So maybe that businesses that insist on how their policies of data protection are a national surveillance proof, well, that could be a competitive advantage in some cases. That's it for this overview of protection of personal data in a business context.